Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I'm right here with you each and every Sunday at this time on this station to bring you, the landowner, the information you need regarding natural gas development here in Pennsylvania. And of course, and as always, I, Doug Clark, the Clark Law Firm, has not, does not, and will not represent gas or pipeline companies. Have not, do not, will not. Never have, never will. I represent the Pennsylvania landowner, oil and gas right owners. The companies have teams of lawyers working for them, and we need to have lawyers working for you. At the Clark Law Firm, I represent landowners for oil and gas lease negotiations, reviews, and consultations on any oil and gas related contracts, pipeline, water line agreements, royalty deduction issues, estate planning, unitization issues, surface use agreements, well pad agreements. Again, any and all contract related to oil and gas development, and any and all essentially issue related to oil and gas development. Give us a call and see if I can help you. A couple other things. Multi-unit wells, multi-unit well consent documents. I strongly urge you to give us a call. There are things that we may be able to do, and I strongly urge you give me a call and see if we can help you. And look, as I say all the time, if you don't like what you hear, then that's okay. But give a call, find out, especially, well, I shouldn't say especially because of anything, but these reviews and consultations. And I'm going to tell you, I'm going to show you something today that if it doesn't tell you, if you're considering a lease and you don't hear this and say, wow, I should do a review and consultation with Doug Clark or somebody else and knows what they're doing, who's fighting and working for landowners, then I don't know if there's anything that will convince you. And I'm excited to just break this down and show you what people are signing and how they have no idea how this document is going to be interpreted going forward. Well, I guess I should say they have an idea, but in my opinion, that idea is completely wrong. And they almost certainly have got this idea from the landman who has told them, who, by the way, works for the gas and pipeline companies, but told the landowner, hey, this is how it's going to operate. As opposed to an attorney working for you who is doing nothing but oil and gas law, fighting for people every single day, who's going to tell you how the companies are interpreting this language, how you read something, you may be told something, and later on you're going to be extremely disappointed. And that's the information that you need. Not the information that the company wants you to have, but the information you need. I talked last week. A landowner reports to me, the landman said, oh, you don't need an attorney. What are they going to do? They're just going to charge you and do nothing. No. What I would do would truthfully, for my client, explain what this document is, talk to them what can possibly be negotiated, what may not be negotiated, what are the market conditions in your area, what are the negatives and positives of the lease agreement, answer your questions, address your concerns as to what these things mean, and to give you all of the information, again, that you need, not that the company wants you to have, in order to make the right decision for you. That right decision may be to go right to signing of that lease. It may be that. I gotta be honest, it's often not. It's usually, hey, look, I'm going to wait to see if the market improves or if the offer may improve, or it may be, okay, I think that this offer is good enough that I'm going to go ahead and try to negotiate it, either with or without my assistance, but that's your decision. So do I want to negotiate and try to increase the bonus, the royalty percentage, the addendum language to add terms? It's not the number of addendum terms. It is the quality of the addendum terms. Do not be fooled by an addendum that has a bunch of numbers on it. Many of them are what I call throwaway provisions that you don't even need, but they look good. It's a salesman point to say, hey, look, you got all these addendums. Well, I don't care if the addendum says they have to reclaim the property when they're done, because I assure you they have to do that anyway. So that's just one example. I don't want to go through all that today because I think I have a great breakdown of some lease terms that if you don't find these interesting, again, if you don't find this interesting or enlightening, I don't know what else I got for you because to me, this is pretty fascinating stuff. If you care about this stuff, if you don't care about it, hey, you don't care about it. But if you do, this is important stuff. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. By the way, I have now been doing All Things Marcellus, the weekly radio show for landowners, since 2010. We have hit 8 years. We're past 8 years at this point, and we're not stopping because there's information that needs to get out there. And so whether you ever call me, whether you ever retain us or me, that's okay. Keep listening to the show. Keep going to the websites. Keep getting information because that's how we're going to raise the bar for everybody. Websites, pagasleaseattorney.com, pipelineattorney.com. If you are interested in this stuff, if you have a lease offer, you have a pipeline offer, and you are not going to pagasleaseattorney.com, pipelineattorney.com, my question is why? And I think the only good answer is because you don't have a computer or access to a computer. Remember, the websites and the radio show are not specific advice, but I think there's really good general information and advice on those websites to get you thinking, to get you understanding, and asking the right questions. Ask the right questions. Get the right information. So we need to stop having people routinely being taken advantage of. We have to stop it. How do we do it? We put the pen down and we pick up the phone. We stop signing bad agreements. We remember at all times that the landman works for the company, not us, the landowner. We understand, hey, look, whether it's with Doug Clark or somebody else, call, do a review and consultation. Like I say, I do this by phone all the time. We do them in office too. If you want to come here, that's wonderful. The phone call usually takes about an hour, and then the other time is just reviewing the information. So these reviews and consultations usually take 1 to 2 hours. And I'm going to tell you, what I'm going to discuss today would have all been revealed to you in less than 2 hours. And I think you might find it very important. Now, you could hear this information again and decide to go ahead and sign. However, you may hear this information and say, wow, I'm really glad I heard this because I didn't understand this and I didn't know this. And I'm going to tell you that that's normally how these calls end, in almost all of them. So I want to do nothing but give you the best information you can to make the best decision for you and your children and your grandchildren and so on. This is an incredible asset. This property, your property, may be an incredible asset. You need to make sure that you do the best you can with it, that you preserve it, and that you maximize your financial potential with your assets. In most cases, these are one-time opportunities. So you need to maximize this one-time opportunity. Again, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give the office a call. See if we can help you. See what we do. Again, any oil and gas related matter, royalty issues, anything. 570-307-0702. Also, buying or selling, buying oil and gas rights. If you're considering it, I cannot recommend enough. Give us a call, learn about the review and consultation, and I will explain what you need to be aware of. I will explain issues or potential issues with the sales agreement. I will explain what we have been able to negotiate out of these sales agreements or increases in compensation when people are selling their gas rights. I can also, in cases, contact companies, find out what the potential activity is or when the potential activity is. I have had multiple cases where people were on the verge of selling their gas rights, called me, and I was able to find out within months there were going to be multiple wells drilled into the unit where the property is. And when the people found that out, they made the decision not to sell the gas rights, and now royalty payments are coming in, and they cannot be or could not be happier. Could not be happier, saying, thank heavens I made that call when we got that information, because that was life-changing for us. Now, again, I can't say that that happens all the time, but I can tell you it's happened at least twice in the last year. So, the worst thing that can happen, and this is not about me just trying to generate business, is saying the worst thing that can happen to you, if you do a review and consultation, you get your questions answered by somebody who has nothing but your best interest at mind and heart. You get answers from somebody who's doing this every day, from the legal side of it, who's negotiating these agreements, who's negotiated hundreds and hundreds with over, I think, 70 different pipeline companies. I don't know how many different gas companies. You can get this information generally and it will have your questions answered and understand the issues about your lease and what you need to know. Again, typically in 1 to 2 hours. What are you doing? People are just signing, and it's driving me crazy because, again, if you don't call me, please call somebody else. But call somebody who's going to work for you to answer your questions. Get your questions answered by somebody who's trying to help you. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station. So, okay, let's get into it. So, boy, this is going to be fun. Well, it's fun, but it's scary. So I'm going to go through a lease. And, look, I talk a lot about royalties, but I have to talk about this. I have to talk about this because this is just an outstanding example. And if you listen all the time, you say, oh, here he's going to go talk about royalty without deduction and deduction issues. Number one, you're correct. But number two, stay with me. Stay with me today because I'm going to go through a lease addendum and a lease royalty provision and explain to you how a landowner is going to be under the impression that they have no deductions. And then on the back end, they may have as many deductions there is possibly allowed by law. But the landowner sees a heading in their addendum that says royalties, let me make sure I get this right. Royalties, all capitals, underlined, royalties without deductions. If you see royalties without deductions, that's a buzzword because we want it. But I'm going to tell you that's not normally what people receive when they have a heading that says royalty without deductions. So let me walk through this and explain this. So we're going to start here in section 1 and segment 1 of the show. And I'm going to explain how this is going to operate generally, and then we're going to dive into the specifics in the following segments. So, we have a gas lease, which is the form document, usually 2, 3, 4 pages, usually. And on top of that gas lease, or attached to it, there is probably an addendum. Again, the company's probably going to throw you an addendum the first time that doesn't have a lot of great terms. Now, they may give you better terms. Who knows? We'll see. But there's going to be an addendum there. A lot of times, those addendum terms that the companies offer initially are very weak and really don't do much for you, but they look good. And they have really cool headings that make you think, man, I'm getting something good here. This is great. Look what I got. And it's designed, in my opinion, to say, oh, wow, royalty without deductions. I don't need a lawyer. Royal says right here, royalty without deductions. Well, again, we're going to explain that. So we have the lease that has a royalty provision, which will say something like, and again, I'm going to get specific next segment, saying, oh, okay, we're going to pay you 50% royalty for oil and gas, and then it goes on to say how it's going to be calculated. Then you have the addendum. Your addendum term may or may not have a royalty provision. Interestingly, as an example, and why you have to look at your addendum and look at the underlying royalty language, I, in this past week, had a royalty addendum presented to me by a company which was literally in the addendum the exact verbatim royalty provision from the body of the lease, meaning that in the lease where it addressed royalty 15% and calculation method, the company just copied that, put it into the addendum. So I guess maybe a landowner or I am supposed to think, oh, well, I got a royalty addendum, that must be good. Well, we know we need to read these words, not just look at the addendum and something that says royalty. So what I'm going to do here in this show is explain how a person believes, and in my understanding, from a direct representation from a landman, that they have royalties without deductions, when in reality, they may have one of the worst royalty calculation methods that you'll ever see. And you say, how is that possible? Well, the good news is I'm going to explain it right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. Again, I've been doing this show for 8 years, and I'm not stopping. Give us a call, learn about the services. I have not, do not, will not represent gas or pipeline companies, only landowners, gas right owners. Give me a call, see if we can help you. Any oil and gas related issue, don't be afraid to pick up the phone. 570-307-0702. Regardless of your location. I've had clients all across the country and in other countries. Represent people all across western Pennsylvania, northern Pennsylvania, anywhere gas producing areas in Pennsylvania, or potentially give us a call and see if we can help you. And if you don't like it, hey, that's okay. But give us a call, 570-307-0702, and stay tuned because I think this is really interesting. Stay tuned. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus, and give us a call, learn about the services, 570-307-0702. 570-307-0702. Remember, a couple highlights. Multi-unit well consents. If you have a multi-unit well request where you're asked to consent to a multi-unit well, I really encourage you to give us a call. A gas lease amendment and modification, those can be deadly. Give us a call and find out what's going on, do a review and consultation. Of course, pipeline agreements, any other type of an agreement or issue, royalty, so on, unitization, give us a call at 570-307-0702. And remember, I do all these reviews and consultations myself. You're not getting them with anyone else. We can get on the phone, come to the office. I want to give you the information you need. Okay, so here's what we're talking about. A gas lease presented to a landowner. Landman says, hey, this is royalty without deductions. Says, oh, hey, this is the only company, one of the only companies in Pennsylvania pays royalties without deductions. Here's the addendum term that is the basis of those statements. The addendum states, all capitals in the addendum, the added document or added pages to the form gas lease. All capitals and underlined the words royalties without deduction. Well, what more do you need to read? The words underneath. That's what more you need to read. The words underneath the statement, royalties without deductions. And why? Because the lease itself says captions, titles, headings appearing at the beginning of any sections or paragraphs or subdivisions of this lease are inserted for convenience of reference only. They do not constitute any part of the lease and shall be disregarded in construing or interpreting the language thereof. I hope that comes through. I need to re-emphasize this. The lease addendum says, heading, caption, royalty without deduction. Landowners say, hooray, I'm getting royalties without deductions. Because they read the heading or caption that says, in all capital letters and underlined, royalty without deductions. However, if they read the fine print of the lease, they would see that a provision specifically in the lease says that these captions, titles, and headings appearing at the beginning of any section, paragraph, or other subdivisions of the lease are inserted for convenience only, convenience of reference only. They do not constitute any part of the lease, and please pay attention to this, and shall be disregarded in construing or interpreting the language thereof. Meaning, the words royalties without deductions in all caps and underline mean nothing. Mean nothing. They don't mean anything. But boy, are they big. And boy, are they bold and sitting right there. And boy, is that something that I'll bet the landman is going to talk to you about. See here, royalty without deductions. Say, well, sir, ma'am, how about in the gas lease where it says that those words mean literally nothing, that they're disregarded, that they mean nothing? Ask that question. Okay, let's get past that, I guess, smart trickery, I would call it. Let's go past that for a minute. Hopefully that point is made. You see the words royalty without deductions. Those words are, by definition in the lease, to be disregarded if there's ever a dispute. So what does that mean? We have to read the language underneath. Underneath the disregarded heading, we need to read the language. The disregarded heading of royalties without deduction. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So here we go. And I'm going to tell you guys, this is really familiar. This is familiar language. You listen all the time. This is really familiar language. It is literally in probably 25,000 plus leases in Pennsylvania. I know for sure it's in the 10,000 plus. I know for sure it's in that. So royalties without deductions. Here we go. Royalties shall be paid without deductions for the cost of producing, well, they can't charge you those anyway, gathering, storing, separating, treating, dehydrating, compressing, processing, transporting, or otherwise making the oil or gas and or related products from the leased premises ready for sale or use. So I have to say it again. There are, paraphrasing this, there will be no deductions of those itemized lists: transportation, treating, dehydration, compressing. No deductions in order to make the gas produced from your property ready for sale or use. The question now becomes, when is your gas ready for sale or use? This has created a location element that it is extremely important that we know, because this is the basis of how your royalties will be calculated. When is gas ready to be sold or used? Because at that point, once the gas is ready to be sold or used, any expenses, transportation, gathering, compression, dehydration, and so on can be deducted. So it is critical that you understand that this is a location element. Where is the gas located when it is ready to be sold or used? And I'm going to tell you, as a guy who's involved in major royalty litigation, that the vast majority of companies in Pennsylvania have made the determination that gas is ready to be sold or used the moment it hits the surface of the earth. This is especially true all across the northern part of the Pennsylvania and even the western part, most of the western part. But the critical point is that most companies, the vast majority, not like 51%, the vast majority of companies determine that the gas is ready to be sold or used the moment it comes out of the ground. Where does it come out of the ground? At the wellhead, at the well site. So, if that gas, the moment it comes out of the ground, is immediately ready to be sold or used, let's look at this language again. Royalties shall be paid without deductions for the cost of producing, gathering, storing, separating, treating, dehydrating, compressing, processing, transporting, or otherwise making the gas ready for sale or use. Well, if it's immediately ready for sale or use, then none of those deductions that you won't be charged are now relevant, because there were no compression charges, dehydration charges, treating, storing, gathering, pipeline charges involved in the production of that gas to get to the surface of the ground. So, technically, then that interpretation would be valid if the gas is ready for sale or use at the wellhead. There are no deductions because they didn't have to transport it in pipelines. They didn't have to compress it. So they're saying it is immediately ready for sale or use. So now, when you take that gas from the well site, you put it into a pipeline, you compress it, you dehydrate it, you move it and transport it to the marketplace where it's ultimately sold. All of those compression, treating, dehydration, transportation, gathering charges, those are all going to be deducted from the sales price. And you say, well, no, that's not possible. Look, my lease right here, the addendum, royalty without deductions. No, it is, we will not charge you deductions at any time prior to when the gas is ready to be sold or used. But once it's ready to be sold or used, we now are wide open to charge you deductions. So, if gas is immediately ready to be sold or used, every pipeline charge and fee is immediately deductible. It's immediately deductible. So you give people a heading that says royalties without deductions. Secretly, well, if you read it, in the lease it says those words don't matter because they're headings and they should be disregarded if there's ever a dispute. And then you say, okay, royalties without deductions, we won't charge you any pipeline fees or other fees until your gas is ready to be sold or used. But we're not going to tell you that our interpretation is the gas is immediately ready to be sold or used. So, of course, you're not going to get deductions when the gas is immediately ready for sale or use. It's now from the wellhead on where you're going to see the exact deductions that you were trying to avoid. So, hypothetically, we'll say, if a landman directs your attention to this language and says, oh, look, we pay without royalty, without deductions. We're one of the only companies. We're the only companies. We're the greatest guys in the world. Say, well, excuse me, sir. Are you familiar with the Chesapeake case? Demchak versus Chesapeake. Are you familiar with the fact that the vast majority of companies in Pennsylvania have declared that the gas is ready to be sold or used the moment it hits the surface of the ground? And therefore, sir, that once that gas is put into a pipeline and transported to the point where it may be sold, all of those fees are deductible and charged in a prorated basis to me. Are you aware of that, sir? Are you aware of that? Are you aware that some companies have originally started to pay without deductions with this exact language and then switched? And I know at least one company went back and said, hey, you have this ready for sale or use language. We could have been taking deductions and we weren't. And now we're going to start taking deductions. So we're conforming with the industry in Pennsylvania with this exact same language. Oh, and by the way, we could have taken deductions and we didn't. And we're going to charge you back that money that we should have deducted, but we didn't. And so however many dollars that is, in one case I was involved in, I think it was around 30 or 40,000, you're not going to get a royalty check until we recoup all the deductions that we didn't take previously. So you could very well sign this, and there's no one who can tell you anything different. Unless, well, they can tell you. People, as we know, people can say anything, but no one can tell you anything truthfully different. That this language is interpreted by the vast majority of companies in Pennsylvania that the gas is immediately ready for sale or use, and therefore every cost and expense that is incurred from the well site is able to be charged to you on a pro rata basis, which is, again, exactly what you wanted to avoid. So ask that question and see what they say. And if they're going to tell you the truth, they're going to say, yeah, that's true, but maybe they might say we do it differently. Well, even if that were true today, it could change tomorrow. They could sell your lease to another company who, like most companies and almost all companies, would take full deductions the whole time. These guys can change their opinion. Why would one company with the exact same language not take deductions when all these other companies with the exact same language are taking deductions? Landowners who see how much deductions are taken from their checks realize how big an amount that is, how much money that is. So if a company had the ability to take those deductions and they just say, nah, we're not going to do it. Even though everybody else takes deductions with this language, we're not going to do it. Does that make sense? Does that make business sense? That could literally be, depending upon the company and the location, that could literally be hundreds and hundreds of millions of dollars in a year. So, royalty without deduction, ready for sale or use, we take it. It's better than nothing, but I'm going to tell you that the vast majority of companies and the vast majority of people in Pennsylvania with this lease term have deductions being taken. Because all these companies that do this, which is the vast majority, yet again, they declare that the gas is immediately ready to be sold or used at the well site. They'll say, hey, it's high enough methane quantity, it doesn't have water in it, we don't need to separate it, therefore it's immediately ready to be sold or used, and by us moving it from the well site, all of those expenses can be shared with you. Any and all expenses that we incur. And sometimes, not only will they say, hey, look, the gas is ready to be sold at the well site. Look, we've sold it to an affiliated company that we own. We own the company, and we sold it. So the gas was sold, plus it was ready to be sold and used because of the methane quality. You have to know these things. It doesn't have to be, but it might be the difference of whether you sign this agreement or not. It might be that you say, hey, look, I want to fight back and get this language that actually means no deductions. There are a few companies that I deal with regularly today that literally are giving legitimate royalty without deduction language. And if that is out there and you're not getting it, you're making a huge mistake. I mean, we're talking massive amounts of money. And you need to know this, and you need to make sure that you understand what your language means. And if ultimately you decide you're going to sign, that's great. An informed decision is a wonderful decision. Most of my clients, ultimately sign agreements. The thing is, We want to make sure that you understand the strengths and the weaknesses and no surprises in the future. And an honest assessment of what I may be able to do, what I've seen in the past, so you have the tools to make the right decision. But my heavens, we can't have people just keep signing documents thinking, oh, I have royalties without deductions, and then you find out later, not what I thought at all, and the person that told you that is long gone. Long gone. And the company says, well, read the language. Gas is ready for sale or use immediately, therefore we're entitled to share any other charges afterwards, and that's what we have. But my lease says royalty without deduction. Look at this addendum heading, royalty without deduction. Yeah, well, look at this other paragraph where it says these captions and headings mean nothing. This is things that we need to know and things that you need to know. Now, the next phase of this, phase 2, you have an addendum where you think you have royalties without deductions. Now, we just said that the vast majority of companies are going to determine that gas is ready to be sold or used at the wellhead, meaning that any other expense or charge afterwards potentially could be deducted. So now what do we have to do? We have to go to the body of the lease and read what that says and see what deductions are allowed to be taken. Because remember, if gas is immediately ready to be sold or used, immediately at the well site, now the company is allowed to take deductions. So we better go look at the lease language and figure out what deductions they're allowed to take. And I'm going to read that in this next segment. And let me tell you, as you might expect, they're awfully darn broad. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give me a call. Call the office. Learn about reviews, consultations, gas lease negotiations, pipeline agreements, surface use agreements, again, multi-unit well consents, lease amendments, modifications, anything. Selling gas rights, buying gas rights, especially selling. Give us a call. Do review consultation. Let's get started and get you information. 570-307-0702. Remember, the radio show is never specific advice. My specific advice is get specific advice. And that's what these reviews and consultations are. Again, join me each and every week for All Things Marcellus. We're not done. We're going to go to lease next and see what deductions are allowed to be taken, because we know the company is saying that immediately the gas is ready to be sold or used, and so deductions are free game right from the well site. What deductions can be taken? Stay tuned. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. Give the office a call. See if we can help you regardless of location. Give us a call. Find out what we do. See if we can help you. 570-307-0702. That's 570-307-0702. Remember, we got to put these pens down, pick up the phone, and get the information you need to make a wise and informed decision. You often only get one chance. Let's maximize it. All right, we're talking about, just very quickly, the royalty addendum said royalty without deductions. That addendum said there will be no deductions in order to make the gas ready for sale or use. But then once it's ready for sale or use, deductions are now free game. So the question is, when is gas ready for sale or use? And the vast majority of gas companies in Pennsylvania say that the gas in Pennsylvania is ready for sale or use the moment it comes out of the ground. So, as it is moved, transported from the well site forward, those fees and costs and expenses can be deducted from the sale price of the gas so that your royalties then are paid based upon the well site price. And that's not what we want. So, we have figured out that, in my opinion, in this example, for the vast majority of companies, that the royalty without deductions addendum, in my opinion, is a bit of a sham, if not a sham, because the vast majority of the companies say that the gas is immediately ready for sale or use. And other companies that may not determine it that way very well may change their mind. Also, what if there's a court case that says that gas is ready to be sold or used the moment it comes out of the ground? Well, that means that's how your royalties are going to be calculated. So, we know, we listen to All Things Marcellus, we go to the websites, we know that we need to put the pen down, pick up the phone. We know that we need to look beyond the headings. We know that there are many tricks and buzzwords that companies have learned to put in leases and addendums to make landowners feel comfortable, to feel that you have protections, when in reality, once you sign and once all of a sudden these contracts started getting interpreted, it's not what you thought. So again, this is general information. A lot of this, well, this is my opinion, but based on a lot of experience. So let me recap 1 second. Royalty without deduction addendum, we're going to say in this case, literally means nothing. Because for the vast majority of companies, so if you're part of those companies or your lease is ever transferred to those companies, this provision would mean nothing. Because those companies say gas is immediately ready to be sold or used, and therefore any transportation fees or cost after the well site can be shared with you. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. So, if the royalty without deductions doesn't mean anything, in our example here, then we have to turn to what does the lease say with how your gas royalties are going to be calculated. So in this particular case, it says that the company is going to pay you a percentage of royalties, and whether it be 12.5, 15, 18, whatever that number is, let's use 15. So in this case, the royalty term provides that on gas, to pay the lessor an amount equal, we'll say 15%, of the revenue realized by the lessee, the company, for all gas and its constituents produced and marketed from the property during the preceding month. Then it goes on. Revenue realized. I've said this many times. Revenue realized is code for deductions. Proceeds realized, revenue realized is code for deductions. Revenue realized means, after I sold it, how much did I realize of that revenue? But in this case, they even do us a favor. They say, usually we see revenue realized and it's not defined. In this case, they actually define revenue realized. And they define it as, so remember, you're going to get a percentage, we'll say 15% for revenue realized of these gas sales. Revenue realized, here we go, shall mean the gross proceeds received by the company for the sale of the gas produced and marketed from, we'll say, the property, less any and all costs and expenses related to, and then it lists, I believe there are 5 of them. So again, remember, the addendum said royalty without deductions, but we determined that probably means nothing. So now we have to look at how are my royalties going to be calculated? So it says revenue realized shall mean the gross proceeds received by the company for the sale of the gas, less any and all cost and expenses related to, and let's go through them. Number 1, treatment and processing of oil and gas. Number 2, separating liquids from gas. Number 3, gathering and transporting oil and gas from the wellhead to production or treatment facilities and or point of sale. Just pause for a moment there. Remember, that royalty without deduction says, hey, we're not going to charge you gathering transportation, but that is in order to make the gas ready for sale or use. And the vast majority of the companies, again, say the gas is immediately ready for sale or use at the wellhead. So then when we look at the royalty in the lease term, it says that the company can deduct or subtract gathering and transportation of the oil and gas, so gathering and transporting fees from the wellhead to a production or treatment facility and or the point of sale. That's not what you thought you got. Next one, number 4, compression or dehydration. Those also can be deducted, again, from the well site if the company has that interpretation of ready for sale or use, which most do. Then, here we go, and this is my least favorite. Any and all reasonable cost and expenses. I'll repeat that. Any and all reasonable cost and expenses of any kind or nature. Of any kind or nature. So again, you have this royalty without deductions. That's what you think you're getting. The lease then says, they can deduct any and all other reasonable cost and expenses of any kind or nature incurred involving the handling of the oil and gas from the wellhead to the point of sale. So, your whole goal is to get rid of this language. And the royalty without deduction language says in the addendum, no deductions in order to make the gas ready for sale or use. But we know that most companies are going to say the gas is immediately ready for sale or use. So we have to turn to the gas lease, and it allows for all of these other deductions and finishes with the kicker of kickers that they can deduct any and all other reasonable costs and expenses of any kind or nature incurred involving handling of the oil and gas from the wellhead to the point of sale. All right, we'll get into that here in this last segment. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Give us a call, learn about what we do, learn about reviews, consultations, see if we can help you. Put down the pen, pick up the phone. We got to get this information to people. 570-307-0702. Like I say, if you don't like what you hear, that's okay, but just call. See if we can help you. 570-307-0702. Keep listening to All Things Marcellus on this station at this time. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Another reminder, join me each week at this time on this station for All Things Marcellus. We just passed 8 years of doing the show, and we're not stopping. And give us a call. We're talking about these royalty issues, and this is like an example of something, and just one of the things, but an important subject that we would discuss in a lease review and consultation. We talk about what you might be able to do with this and really break it down relative to your individual situation. And that's the key. Remember, the radio shows, the websites, they're good quality, general information to get you thinking and understanding that you need to get more information and then get specific information. I'd love to hear from you. But if I don't hear from you, call somebody who's working for you, who knows what they're doing, who has your interest in heart working for you to help you and give you the information that you need. Do that and call somebody with the experience to help you. But again, I'd love to hear from you. It's what I do, and I love doing my job. I love what I do. I love doing the show. It's an incredible outlet for me because, truth be told, I get so frustrated at times during the week when I hear some of the things that I hear. I see people signing agreements where they think they're going to have no deductions because that's what they're told, and then they're subsequently totally blindsided. And look, there's tens of thousands of people. That's not an exaggeration. The Chesapeake case with these issues had well over 10,000, leases, and way in individuals or people. And that's being conservative. So this isn't like it's some small issue. And what you have is years later, like literally 10 years later, people signing with the exact same language as involved in the Chesapeake case, thinking that they're not getting deductions. And then what's going to happen in the future? So we cannot repeat these mistakes. We have to learn from them. Now, let me say, maybe you cannot get rid of the deductions. Maybe you can't. But you need to understand that they're there. And maybe there's other things that you can do that not necessarily make up for deductions because they're so important, but ways to improve your lease. get this lease. It's like we're going to consult with you over the operations on the surface. If we do that, big deal. Consult with you. Oh, this is what we're going to do. We're going to tell you what we're going to do. Well, if you object, we don't care. We're consulting with you. We've fulfilled our obligation. Just one example. Okay, let me get back to our subject. So what we have, kind of recapping, is we have, in my scenario, a landowner who's given a lease. And the landman in this scenario is focusing on, understandably, a royalty provision in the addendum with a heading that says, or a caption above the main paragraph that says, in all capitals, royalties without deductions. But then we look at the lease and it says that the captions or headings, such as the words royalties without deductions, have no meaning. They're just identifiers to identify the topic. So if you ever go have a dispute, it literally says that those words, royalties without deductions, should be disregarded. So you have to disregard the headings. We can't be lazy. And if you're lazy, that's okay. Get a lawyer who's not lazy, who's going to help you to explain and read the language and decipher it and explain it to you. Because when you see royalty without deductions, in my experience, in almost all of these cases, that's not really what it means. Not what we think it means, not what you think it means. So in this case, royalties without deductions, when you actually read the language, it says we won't charge you all these different fees. And the key words are, in order to make the gas ready to be sold or used. And as we said, most of the companies, the vast majority of companies, say the gas is ready to be sold or used the moment it comes out of the ground at the well site. So therefore, your royalty without deduction language, it says no deductions until the gas, or before the gas, no deductions before the gas is ready to be sold or used. Well, if the gas is immediately ready to be sold or used, well, there are no deductions at that point. But if the gas is ready to be sold or used at the well site, then all of those pipeline fees and all the fees incurred from the well site going forward can be deducted. And that's what you're trying to avoid. So when you read the royalty without deduction language, it sounds great. No deduction, transportation, gathering, compression, and so on. But if those no deduction language, if that immediately doesn't apply because the gas is ready to be sold or used immediately, then anything going forward can be deducted. And I was saying it so many different ways because I want it to come through that if gas is ready to be sold or used immediately, then all deductions are fair game. So then put yourself in the landman's shoes, who works with the company, not you, the landowner. Put yourself in their shoes and say, okay, they're going out to a landowner and their goal is to get the landowner to sign the lease. So they go out to them and they say, what can I point to in this lease as a motivator to encourage this landowner to sign? Well, everybody who's involved in anything with gas knows that you want to have royalties without deductions. So that's why, in my opinion, the companies draft a heading, royalty without deductions. It's not real hard when you deal with it all the time. So the landman says, hey, look, royalties without deductions, royalties without deductions. Again, why don't you point to them and say, well, do those captions, do those words actually matter? Doesn't the lease say that the captions and the words royalty without deductions actually don't matter? What matters are the words beneath? Ask them these questions and see what they say. But it's true. So then we have to look below that. So they're going to point to that, and they're not going to get into the location element as to where is the gas located, physically located, when it is now declared ready for sale or use. And you can ask the landman, well, isn't it true that the vast majority of companies in Pennsylvania have declared the gas is ready to be sold or used the moment it comes out of the ground? And because of that, any charge or expense that is incurred after that moment can be deducted from my royalty. Ask that question. And if it's a wise landman, they may say, well, landowner, some companies may do that, but the company I'm working for is a great company. They won't do that. They don't do that. They are the good actor. I've worked for some of those other bad actors, but this company is a great actor. They're not going to take deductions. I say, okay, well, if you're telling me that I'm going to have royalties without deductions, why don't you let my attorney, or me, but I would go with your attorney, why don't you let he or she write the language of royalty without deductions? Because if you truly want to pay royalty without deductions, if that's your true intent, why does it have to be this exact language? Why does the language have to have a location element to it? If you truly want to pay royalty without deduction up until the time of the first sale to a third party, why not have a royalty provision? There will be no deductions prior to the sale of my gas to an unaffiliated, unrelated third-party company. In other words, let me get the sell price of my gas when you sell it to somebody else. If that's your goal of no deductions, why would you not give me that language? If your goal, if you agree, company, your goal and what you say is, okay, we will not take any charges to move your gas from the well site to the closest or nearest interstate pipeline, because that, in my opinion, is when gas would be ready to be sold or used. So if you want to clarify this, company, let's add a sentence in there that says that there will be no deductions for any of these expenses prior to the time that the gas produced reaches the interstate pipeline. Why? Isn't that easier? Why do we have to have this riddle of when is gas ready for seller use? Why not just say, look, no deductions from the time your gas comes out of the ground until it gets to the interstate pipeline. And then if we don't sell it there and we transport it in the interstate pipeline, then we're allowed to take deductions. And I'm going to tell you, that's really, I think, a really fair deal. Why are we playing games with ready for seller use? Well, we're playing games that way because gas is almost certainly going to ultimately be determined to be ready or sold or used, ready for seller use at the well site. So they will charge all those deductions. Why are we playing those games? Boy, and if you can, replay this, go to the websites, listen to the show again, write down these questions, ask the landman, ask them these questions and see how they respond. Because I'll tell you, there's no good response. And if the landman doesn't acknowledge that the vast majority of companies determine gas is ready for seller use at the wellhead and that everything after that can be deducted, if they don't tell you that, then we can conclude one of two things. Either they don't know that that's true because they just don't know and they don't have that information, or they know it and they're not being truthful. I am not saying which one it is. I am not making any accusations. I don't want any letters from landman groups. It's one of those two things, though. You either don't know or you're not being honest, because I'm sitting here telling you that the vast majority of companies in Pennsylvania determine gas is ready for seller use at the wellhead and immediately start deducting anything they can after that point. So ask the landman. Maybe the landman just doesn't even know what's going on. Maybe they've never studied marketing of gas. They're representing the company and they see those big bold words, ready for a royalty without deductions. But we got to be smarter than that. All right, let's wrap this thing up. You're listening to All Things Marcellus. You have been listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I really encourage you, give us a call, learn about reviews, consultations. If you're selling gas rights, multi-unit wells, any of those items, give us a call, 570-307-0702, 570-307-0702. Remember to tune in again each week at this time on this station for All Things Marcellus. And most importantly, put down the pen, pick up the phone, let's stop signing bad agreements. And I should say, most importantly, have a great, great week, everyone. We'll see you next week.